Okay, good morning, everybody. It's my greatest pleasure to have Dr. Daniel Fiott with us today. He's going to discuss a very important issue, that is the defense industrial cooperation in the European Union. And since you're not here to listen to me, but to him, without any further delay, Daniel, the floor is yours. Thank you very much for accepting delivering this talk to us.
Good morning, and thank you so much, Yanis, first of all, for the invitation, a very, very kind invitation. And just to formally thank the National Defense Academy of Latvia as well. I know in the past we tried already sometimes to get me to Riga. It wasn't always possible. And I guess one of the blessings of this online world now that we live in during this pandemic means that at least I can be with you virtually. I hope in the future that I get the chance to come again in person to Latvia. I miss it very much. Thank you again, Yanis, for basically giving me an opportunity to outline the main arguments I make in my recent book on defense industrial cooperation in the EU. And also, if I can, just to maybe link the academic research or the academic thinking in the book with some of the recent developments that have taken place at the EU level since about 2016. So if I give you first maybe a little bit of history, the book was written between 2013-14 to 2017. That's when it was already getting prepared for publication. But in 2016 already, we saw some big developments with the European Defence Fund, which I could speak about a bit later, and also other initiatives such as permanent structured cooperation. So as many of you will probably know, from about 2016, after the global strategy publication, the EU started creating a whole set of new instruments designed to develop capabilities, to finance defense projects, capability projects, defense research and innovation, and so forth. So in the last few years, we've seen hyperactivity at the EU level. And my book kind of precedes this a little bit, but some of the main arguments I think are still relevant. Let me just say that I'm also very pleased because I recently learned that the book itself will now go from hardback to paperback. And that's nice, if anything, because it becomes much cheaper for people to buy, because normally when you publish academic work, it's so expensive that no one buys it. So I'm very happy that people will be able to access it a bit more. Now, aside from that, what I thought I would do today is give you an overview of the main arguments in the book, then link it with the present day discussions. And then I'm very happy to engage in a question and answer session or a debate with the audience as well, if that is possible. Let me first begin by saying that what really sparked my interest in this field was the puzzling observation that defense industry and the importance of the defense industry from a strategic point of view and from the point of view of national defense, so the ability of a state to produce or acquire military technologies for its own national defense, this traditionally has been thought of as a national sovereignty issue. So as much as possible to keep it within the borders of your country for all sorts of reasons, but principally for the question of national autonomy. Now, in that sense, the idea of cooperating with partners across borders is not necessarily new. And that can be explained rather easily. And that is to say that no single country, maybe with the exception of the United States, but even there are some questions, can claim to be fully autonomous when it comes to technological development or defense capability development. So you will always have this natural transnational or cross-border feature within defense industrial cooperation. And I should say as well that normally that type of cooperation across borders is it walks alongside the idea that a country wants to develop its close defense partnerships with other countries. So the obvious case here is of countries with, say, a smaller defense technological industrial base, looking to someone like the United States, which offers high-tech equipment, which offers obviously a sizable defense catalog or product catalog, and it enables those countries not only to buy from the United States, but also to develop their defense relationship with the US. So it's not just about industry, it's also about defense alliances a bit more broadly. Now, that is not so puzzling, but what was puzzling for me is, well, why is it that a number of European countries and EU members in general decided to organize this cooperation in defense industrial matters at the EU level? That is to say, why did they not decide to continue the pattern of working in smaller collaborative roles or mechanisms? Why did they not continue just to simply develop a bilateral relationship with the United States? Or why did they not try to organize cross-border cooperation within NATO? So what was it about the EU that was so attractive for many member states? And that is really the central research puzzle that I look at in my book. And that's also the question which I try to answer in the book. So with that in mind, one of the, I would say, there are many theoretical explanations as to why this would happen within the EU. Some scholars, I think, perhaps unconvincingly, have pointed to the idea of the construction of the EU as a defense actor as being the sole premise behind why member states would want to develop a defense industry within the EU context. I don't personally find that too convincing, because it kind of ignores the importance of economic interests. So the defense industry is not just about strategy and politics, it's also about economics. So you can't base your whole industrial strategy as a nation state on the ideal of EU defense cooperation. I simply don't think that works. So I had to look around for other theories. And of course, you could argue that realism to some degree, or neorealism, gives us a window into why member states would collaborate. And there are some convincing elements in realism, in particular, the idea of alliance building and also of ensuring that you can, in an indirect way, cooperate to lower the costs of acquisition for defense equipment and technology, and thereby, as an alliance, as a group of states, thereby profit from economies of scale. I mean, that can also be quite convincing. It could also be convincing from a realist point of view if you take a more systemic view of the defense industry on a global basis, to say that if we accept the idea in realism that the defense industry is a core component of a military capability, so your ability to produce capability or develop defense technologies, then you could argue that under the pressure of international competition, the Europeans came together more, or were pushed more together to try and cooperate in defense industrial matters. I think that can be relatively convincing, but I don't think it takes us far enough, if anything, because it kind of ignores the special dynamic that takes place within the EU. And for many of you who maybe know a little bit about how the EU functions, it is a very bureaucratic and very legalistic organization that is actually founded on the idea of compromise between partners and member states. And so it is, I think, a bit hard for realism to try and explain or to try and unite the inner workings of the EU and what may be so attractive about the EU as a venue for cooperation versus some of the systemic constraints and military considerations that are inbuilt in realism. So on that basis, I had to try and look for a theory that kind of combined the two, that would allow us to look at how the internal EU dynamic, policy-making dynamic works, while also not ignoring the systemic and strategic dimensions to the defense industry and to defense industrial politics. And for that, I found the work of Andrew Moravcsik, so-called liberal intergovernmentalism, as a pretty useful theoretical tool in this regard, because it allows us to look at how member states negotiate within the EU. It also allows us to look at how those member states, so as sovereign states themselves, how they also form their own defense policy and defense industrial policy considerations. And that, of course, is important in an EU context because no legislation, no mechanisms can really be developed without this compromise, or without a sort of kind of bargaining, as the theory calls it, bargaining between member states within the EU. So I found liberal intergovernmentalism to be rather convincing, and maybe not to bore you too much with the academic theory, but liberal intergovernmentalism essentially has three components. I mean, it's called a kind of meta theory for a reason. It's quite broad, and it combines a number of theories. The first thing is that within the theory, we have to focus on what is called national preferences. You and I will probably know that as national interests, okay? So what are the core preferences or interests of member states? The second step in the theory is bargaining. So intergovernmental bargaining between these governments that have very, very different preferences sometimes. And then finally, the theory focuses on the outcomes of that bargaining. So what is it that when member states agree on something, how do we make sure at the EU level that that is locked in to the policy framework? Now, maybe before going into some specifics, it is important to note that liberal intergovernmentalism doesn't really reject the idea of realism. In fact, there's a lot of realism in liberal intergovernmentalism. But the liberalism is the key word here. It offers the opportunity for bargains and cooperation to occur, whereas if you take a very simplistic reading of realism, that is not really supposed to happen if the emphasis is on a national sovereignty, okay? So it makes that claim, firstly, that cooperation is possible and that member states or states can agree to that cooperation as being beneficial. The second thing it makes, claim it makes, and this is maybe a bit challenging for anyone who looks and focuses on the EU as a set of institutions, the theory does not really give that much importance to institutions. It may seem odd to say this, but its emphasis is not really on the role of institutions in creating policy outcomes or legislation or bargain outcomes. That's not really the function of institutions. In fact, liberal intergovernmentalism states that institutions are only really important in the third stage of policy development, so outcomes. Okay, so once member states agree, then it's up to institutions to enforce what they've agreed, to enforce the bargain. But the theory doesn't really allow for much space for these type of institutions to influence policy. Now, I'll come back to that point a bit later, because actually in my book, I contest this point. And I say it is a weakness of the theory, actually. But before doing that, let me talk a little bit about each of the steps of the theory, because I think it's important in the case of defense industrial policy. The first step, as I said, is on preferences, the focus on preferences. Now, this is a bit complicated because if you read the work on liberal intergovernmentalism, it stresses economic preferences. So it looks very, very specifically at a given country, And it looks, for example, at government policy. So how does government want to direct economic policy, industrial policy? It then also looks at the interests of firms, so industry, that exist within the borders of that country. What are their interests? What are their preferences? And then more broadly, you can also bring into this discussion trade unions, industry associations, even civil society. I mean, let's not forget, in the defense industry in many countries, there can also be a strong lobby against this industry. So when you start to break down countries, you see that there are a whole multitude of different preferences that need to somehow be mediated by governments and represented by those governments. Now, one of the points I argue in the book is that to call to state that only economic preferences matter in the case of the defense industry is false. It is not correct. In fact, what we see is an even more complicated picture of governments trying to represent, on the one hand, economic and industrial interests, while on the other hand, also forwarding and advancing strategic, political and defense interests as well. So they have to balance these two. And of course, that can have a very, very big impact on government policy. It can decide what type of armaments or technologies to acquire by any given country. It also indicates that there is a balance to be struck for governments between, on the one hand, supporting national defense firms versus supporting or buying from outside firms, from third parties, from third states. That balance is, of course, not always easy for many countries because there is the countervailing pressure to make sure that their own industry is supported, especially in this sector. And that's really important because, as many of us know, the defense industry does not really function like any other industry. I remember once the former president of the European Council, Herman Van Rompuy, and he said, you know, the defense industry, it's not like making shoes. So it's not like the normal market rules apply here in terms of cheaper prices, a wide customer base and so forth. The problem for the defense market is that you have one customer, normally the government, and you only have a handful of defense firms that can produce the required capabilities. So it's very difficult for governments to balance, as it were, the economic and political interests. And actually, the more and more you look at it, and the more and more you look in depth into countries, into individual countries, which is something I try to do in my book as well, you see that ultimately it's a bit of a fallacy to try and separate economic and political interests. It's not really possible because whenever a government policy is decided upon or political decisions are made, they normally are a balance between economic and strategic interests. That's the reality of most governments. So I push back firstly against the idea that it's all about economics. It's not in this case. It's also about strategy. But let's imagine that governments in Europe are able to represent their preferences, to mediate their preferences at the national level. Well, when they then decide of how best to cooperate with each other to secure these national interests, they can take a number of decisions. Cooperation doesn't always have to be the rule. In some cases, and in some countries, they may decide that cooperation is really not beneficial, that it's much better just to do it on a national basis. Other countries may decide that cooperation is important, but let's do it maybe on a bilateral or even a minilateral basis. And then otherwise, governments can decide as well, alternatively, to organize their cooperation at the EU level, so at the international level. So it's not a foregone conclusion, by the way, that governments will always look at the EU as a natural place to organize defense industrial policy. Now, a few things need to be said here. The reason why states take this decision about whether to cooperate or to stay national or to maybe go regional or bilateral is dependent on a whole number of systemic factors, firstly. The first one and most important one is what is the size of their industry? And this is a big issue because not every country, especially in Europe, can say that they have a full spectrum defense industrial base. Now, if you cannot on a national basis produce everything you need for your military, well, cooperation becomes pretty much the only alternative you have. Unless, of course, you have very, very brave governments who are willing to sink pretty much the whole GDP of their country into defense, which is not very possible for many countries. So do you have an industry? How big is the industry? These are two very big starting points, two starting questions. The third, or the second major systemic issue is actually the level of international competition that governments face. So as I said, it's not just about military strategy, it's also about economics as well. And a huge pressure is placed on governments when looking at, we already know that in international markets, the US, for example, plays a huge role. It is the most competitive defense industrial player in the world. But nonetheless, this presence of the US and the fact that they are able capabilities on a huge scale and at a relatively governments in Europe who are also trying to compete on international markets will take the decision that, well, we could develop a national capability, but then the international level, because the problem that it is very rare, unless you're the United States, but even in the US it's the case now, you have to produce defense capabilities nationally. You also have to export them in order to make sure that you have economies of scale, that you have the value chain fully running so that you're constantly producing, there's constant demand. And also it is clear that very few markets in Europe, and even the big ones such as France, UK and Germany, they still have to export a lot of what they produce in order to make the costs fit. If it was just for national demand, as I said, they would either have to completely expand or revise their defense strategy to produce more and to buy more domestically. But if they're not going to do that, they have to balance between national demand and exports. So there are a lot of structural pressures on why governments decide to cooperate. Now, if we come to maybe beginning to answer the question of why is the EU in this respect so attractive for member states, well, let's presume that a majority of member states agree that European cooperation is needed for defense capability development and for the market. Well, what the EU offers is a strange kind of venue for them. The first thing to keep in mind is that if we look at governments and states in Europe, they are highly unequal when it comes to defense industry. We know, for example, that 80% of what is produced in Europe is done within about 5 or 6 countries in Europe. The other countries in Europe play more of a role when it comes to small, medium-sized enterprises, defense innovation, and also being part of the defense supply chain, so to speak. Now, what the EU offers is a certain level of equality between these governments. So the states that walk into negotiations, even though they have large industries, have to bargain, they have to find a compromise within a legal framework, within a policy framework that presumes in defense matters that states are relatively equal when it comes to their say, when it comes to their veto power, when it comes to their ability to influence negotiations. So that's quite attractive for many governments, especially the smaller ones, because they see an opportunity to say, well, if we bargain for the EU, then at least we can try to get the terms of trade and terms of bargaining and negotiation in a much better place than if we had to do this in, first of all, in any other organization, which doesn't really function like the EU, or on a bilateral or mini-lateral basis where the economic and industrial disparity between governments in terms of market size would play a much bigger role in deciding outcomes of negotiations. So the EU in that respect can be seen as quite attractive, I would say. A second thing that we need to keep in mind is that the EU principally, and it's still the case now, even though a number of new policies have been designed, but it's still principally the case that the EU is seen as a market power or as a convener of the single market. Now, that's also really, really important for governments because they need to know that if they're going to cooperate with each other on defense industry matters, that there should be a level playing field between them. That is to say, that it would not be really ideal for smaller countries to participate in a structure which was rigged against their interests. That is to say, that only the big boys, so to speak, would get all of the spoils of negotiations and of bargaining. Now, by working through the EU and by working through the single market principles, there is an emphasis placed on the level playing field. Now, what does this mean in practice? Well, this means that when the EU negotiates legislation that relates to the defense industry, it has to do so in such a way that each country has a fair shot, and non-discrimination becomes the principle here, has a fair shot of winning defense contracts, of forming part of defense supply chains, and ultimately, for them, and this is the main interest for many states, to ensure that their national interests and their national industry can benefit from the leverage effect or the economy of scale that is produced or created by negotiating through the EU. So that's also another attractive prospect because it means that the Commission, as the guardian of the treaties and as a player in defense industrial policy, has to always ensure that there's no discrimination when it comes to a government deciding to hand a defense contract to their own firms when, in many respects, they could have got a much better offer, or there was a much better offer from another country. And we know that in the EU, when it comes to the single market, that non-discrimination based on nationality is a fundamental principle in public procurement. And what has happened, and I can say a bit more about this in a few minutes, what has happened is that the EU has taken its public procurement policy and legislation and tried to push that onto the defense sector to ensure that there's a minimal degree of discrimination. And in fact, in principle, the European Commission can even take member states to court, to the European Court of Justice, if it is found that they've breached public procurement principles and rules. So it's another way in which governments look at the EU and think, well, especially the smaller ones, this is a good opportunity to ensure that our interests are cooked in to the legal framework for defense industrial policy. The third step, as I've said, is on outcomes. And this is really, really important because, as I've said, the theory doesn't really see an important role for institutions like the European Commission, at least until a bargain between governments has been struck. Once it has been struck, then institutions such as the European Commission, European Parliament, and even the European Court of Justice should, in theory, have a much bigger role to play in ensuring that what has been negotiated between governments is applied properly, applied fairly. And as I've said, if there are any breaches of EU law, that can be a grounds for initiating infringement procedures or legislative measures against the offending member state. And what is interesting about this final stage, and where the theory also can be criticized, and I have criticized this in the book, is that what we have seen over the last few years and decades is a growing role for institutions like the European Commission. I contend that it is not just their role in ensuring bargains are adhered to. The EU framework, policy framework, legal framework is dependent upon institutions like the Commission to find compromise, but also, and this is important, to also push legal boundaries. And I'll give you one example, if I can. In the treaties, in the EU treaties, there are special legal provisions for governments to opt out of the treaties when it comes to defense, industry, and procurement decisions. And that is to say that if there is a national security issue, let's say a country wants to develop nuclear submarines or nuclear capabilities, or some other capability that they absolutely need to ensure is produced on a national basis for national security grounds, national security concerns, well, on that basis, they can opt out of the treaties. And that would mean that the Commission would not really be able to go after them in this specific sector or capability, and to try and apply open procurement, because no government, when it comes to these really precious and high-tech weapons, will want to be forced to give the contract to another country on national security grounds. And that is called, by the way, Article 346, for those of you who are really interested. It gives member states an opt-out. However, what we have seen over the last few decades has been an abuse of this treaty provision. And in fact, there have been some really interesting cases that have gone before the courts of justice. Apply this national security measure in the case, for example, of the procurement of T-shirts for militaries, or fireproof helmets, or robust shoes, for example. Well, of course, when these member states went to court, the Commission argued that what they were really up to, these member states, was just trying to hand contracts to national firms under the protection of this treaty opt-out. And the Commission said, well, and the court actually said, sorry, that this was not really how these treaty provisions worked. They only worked on the basis of essential security interests. Now, a problem for the EU is that we have never, and I'm not sure it will be possible, we've never defined what a national security interest is. What is an essential security interest? It's not known. So there has to be some judgment or discretion on the parts of the courts of justice when it comes to this. And they, of course, ruled in many cases that, look, you're not going to be able to use the EU treaties to justify handing a contract for T-shirts to your own firm just because you want your military to wear them. Okay, so that's not a good enough grounds. So we've seen the development of these cases over a number of years, and they have given more meaning to the Commission's role in its ability to push back against member states when it sees that member states are breaching the basic principles of the internal market, and making sure that they don't always abuse of treaty provisions that should only be used in absolutely extreme cases. So as I said, for say nuclear weapons, and not for T-shirts. So in a nutshell, that is what the theory tells us. There are, as I said, some weaknesses with the theory, which I address in the book. But then I try to empirically apply this to 3 case studies in the book. And I picked 3 case studies. Firstly, what we call the Defense Procurement Directive. The second one being the Defense Transfers Directive. And then the third case study being the creation of the European Defense Agency. Let me explain a little bit about all of these 3 first, as I go, sorry, and then I'll tell you the implications when it comes to theory. And of course, I rely on Yanis. If I speak too long, he is the one who has to tell me to shut up. So I rely on him for that.
Okay, I will. But go on, breathing. Go on, please.
Thank you, Jens. The first case study, the Defense Procurement Directive. Now, when this was first, when this started to be developed in about 2007, it wasn't fully adopted until 2009. But for a number of years, there were bargaining between member states over the Defense Procurement Directive. Now, what does the directive do? Well, as I said earlier, it basically applies EU public procurement law and legislation, and it puts it within the defense sphere. And it says, under the directive, that governments cannot discriminate when they are contracting for their defense needs and for defense capabilities. They cannot discriminate on the basis of nationality. So if country A wants to acquire a new capability, let's say it's just for illustrative purposes, we say it wants to acquire an unmanned aerial craft, ARPAS or UAV, a drone. When it sets out the procurement contract, it cannot, within that contract, allow for any discriminatory purposes. Now, of course, no government in procurement contracts is going to say, well, we would like this contract to go to our national firms. That's not how it works. They have very, very clever ways of wording procurement contracts. And in some cases, they can use language in such a way as to ensure that the only firm that can really give an offer to meet all of their standards and requirements coincidentally happen to be those firms within their own country. Well, the Commission tries to push against that and says, well, that's not going to fly for us when it comes to the principles of the internal market, mainly because it just replicates a kind of market nationalism, and it doesn't allow for a number of things. But firstly, it doesn't allow for the best offer in terms of price and in terms of performance to be secured by governments. So sometimes, you know, you will pay more for a piece of equipment. It will not necessarily function better, but you're happy that your firms are producing it within your country. So what the Commission is saying and what the EU is saying is that, well, for a proper market to function in defense, we have to be able to get the right balance between cost and performance. And that's really important. The second aspect is about unlocking innovation. The problem is, or the challenge rather, is that many defense supply chains in Europe are still organized on a national basis. Now, this does not give the opportunity for SMEs in other countries in Europe, around Europe, the opportunity to feed into that supply chain, because governments and even firms, it should be said, can be very jealous and guard what their supply chains look like. So what the Commission is saying as well, if we're serious about this level playing field and giving, let's say, in this case, a very innovative firm from Latvia, to give Latvia the chance to be part of supply chains, that is not a bad thing, because you could argue that you are unlocking innovation from across the Union, and you're also maybe getting a product, a component or technology that performs better and is perhaps even better in terms of cost. So if you want to secure those opportunities, it's important to have a kind of internal market for defense. And so that's what the Defense Procurement Directive wanted to do. Now, just a little word on how this was perceived. Many of the larger countries, the ones with the big defense industries, had quite a lot of arguments and discussions about what this procurement should look like, this directive should look like, because some countries were worried that an opening of the market would damage their national supply chains, and supply chains which had been, protected or shielded by governments for many, many years. Now with the directive, the idea was to open those markets up, which was very, very challenging. On the other hand, there were some governments who already had moved to a very open market basis, where they had for many years and decades actually privatized a lot of their defense firms. And they had operated already a kind of semi-privatized procurement system. They were the ones who, in a big way, pushed for the idea of opening up this market within Europe on the basis of non-discrimination. What they hoped by doing this was to say, well, let us use the full force of the market in the defense sector. So the best firms that can produce the best equipment for the best prices, for the best performance, should be the ones who ultimately succeed. So it's competition, essentially. It's market competition. There were other governments, of course, who believed that this could be rather challenging for their own defense industry. Now, how were those governments brought around? Well, on a very specific basis. And that is to say that the prospect of ensuring a single market in defense in Europe, they saw this as an opportunity for them to export goods, to export defense equipment and capabilities around the European Union without necessarily or without having the problem of discrimination. So, just to give you, one example, if a European government is trying to win a contract or a bid with another European Union country, and they're competing with a third state, the idea is that that EU country who may want to give the contract to the third state would not be able to just hand that contract to them. There would have to be a very serious open contract, as open as you can have, of course, open contract, to ensure that there is at least a fair degree of competition between the EU state competing for that contract and the non-EU state for that contract. Now, there are a lot of discussions here as well within the bargaining process, with some countries saying, and in particular France was the lead country here, in pushing for the idea of having a so-called Buy Europe logic embedded within the directive. This was, of course, fought against by other EU member states who thought that there could be the danger that with this directive, you are essentially creating a single market in Europe, true, but a protected one from the rest of the world. And that did not sit easy with a lot of other governments who have a lot of business and dealings with, say, the United States. And it's a funny thing saying it now, because the UK has left the European Union. But of course, the UK and other countries like Sweden were those countries who pushed for a very kind of loose or a directive which did not become too political in calling for kind of Buy Europe act within the procurement directive. So these really politically sensitive issues were part of the bargaining process. I mean, you have governments with very, very different views here. It should also be said, by the way, that we shouldn't just fall into the trap of thinking that it's just governments, because the other interesting thing about bargaining at the EU level or EU level policy is that there are some firms who, for various reasons, do not feel that they are tied to a national government. And in particular, transnational firms in Europe are much more likely or much more comfortable with the idea of negotiating above the heads of governments, of their governments, where they're based. So they can, in a special way, try to reach out directly to the European Commission, also try to use this legislation for their own purposes. And a number of firms thought that it was a very good idea that we have much more free and open competition within the European market. You could argue that one of the reasons why they did this was because they thought that they would benefit from more open market and competition. After all, these transnational firms tend to be huge conglomerates, and they already have a leading market power, and they produce a lot of the high-tech technology that could be worthwhile buying on the defense market anyway. So you could see that they had an opportunity to use legislation to their benefit. So The idea is that it's not just government and commission, but it's government and some firms. It should also be said that there are some firms that did not want EU policy. They feared in some cases that a move to the EU level when it came to legislation would somehow break the link or the privilege link that they had had with their national governments. And they were also concerned that governments would not be able to just simply hand them contracts on a national basis, that they would, because of legal provisions, be forced to give a contract to other parties, which would of course damage their competitiveness, their revenue stream, and so forth. So a lot of these considerations went into this directive. Now, the first thing that should be said, I just take some water before I continue. The first thing that should be said here is that, of course, there are two types of EU law when it comes to EU policy on defense industrial matters. You can either have a regulation, an EU regulation, which, as we know, has a direct effect. So governments don't really have much leeway for interpretation. They simply have to apply the law as is written, to oversimplify. The second form of legislation is what we call a directive, which gives you much more leeway in terms of interpretation. It allows more room for specific national characteristics to be taken on board as you transition to the application of the law. Well, it's telling, I think, and it's a point I make in the book, but it's telling that governments decided to go for a directive rather than a regulation on defense procurement, because it did give them the flexibility. And in fact, and it's the same with the transfers directive, which I'll speak about in a second, it is also true that member states opted for this more softer approach to law, even though now there is much more emphasis by the Commission, which only recently conducted a review or an evaluation of how the directive was performing. And it's now becoming much more difficult for governments to, get out of the provisions of such laws. So it's, as time goes by, the directive becomes more embedded, although there are still questions about how far it's being applied in every member state case. The second case study on the transfers directive was also interesting, I found, because the transfers directive, it's very different to the procurement directive, but it's somehow related. It was also developed and published in 2009. The transfers directive essentially tries to break down the barriers between member states in the single market for the transfer of equipment. What the Commission had realized, and what many governments had also realized, was that it was too expensive, too costly, too bureaucratic to transfer arms and military equipment within the internal market in Europe. And that for them was rather, well, it was not optimal, was it? I mean, given that the idea of the single market is to reduce national barriers, a number of governments in the Commission argued that, well, firstly, we need to remove those barriers at all possible, and we need to try and move towards a kind of single licensing framework, so that there is one European license for a particular transfer and not a whole range of national ones, sometimes written in languages that are not understood by those wishing to export, sometimes customs and transfer procedures being run by different ministries within different member states, different national authorities involved. And so this was seen as, in a way, a confusion, because every member state had its own way of certifying transfers. But also there was the impression that a lot of these barriers were artificially put in place as well to ensure that national firms had more of a fair competition at supplying equipment and technologies than importing within the single market. So the idea of the transfer directive was to remove that by putting in place a kind of single licensing framework. Now, the discussions there were also really, really interesting, at least at the bargaining phase. Again, a lot of the transnational European defense firms were calling for this. They argued that we needed to remove barriers between countries so it became easier to transfer military equipment and technologies. But also a number of governments as well. And again, there were some governments who said, well, absolutely we should remove these barriers because it will increase competitiveness, and it will also ensure that, again, smaller firms will be able to export their equipment and their technologies as well without necessarily falling foul to these kind of indirect trade barriers. And you've really got to focus, I think, on the how to put it, the kind of nitty-gritty minutiae of exporting to a third country. I mean, if you're a small or medium-sized enterprise in the EU and you have a really good defense technology that you want to export to a larger country for integration into a defense system, well, firstly, you have to understand who the correct authority is to issue that license. Secondly, you probably need to speak a different language. And thirdly, it probably means that you need to employ quite a lot of lawyers in order to be able to understand how that process works. Now, if you're an SME, you don't necessarily have those resources, do you? Or that money. It's just impossible for you to recruit a world-leading lawyer who can help you with procurement in another EU member state. So by putting in place the transfers directive, these types of problems were supposed to disappear, although, as I've said, they're still with us. So competition and open markets were seen as two core objectives. But it should also be said that because we're talking about transfers of equipment, a different issue came to light. And in particular, I remember, and it's in the book as well, the problem that was seen between allowing internal transfers of military equipment and then seeing how that related to the exportation of equipment outside of the Union. And there was a fear by a lot of member states that, well, if we reduced barriers in the EU, this would simply allow one government to export to another government within the EU, and for that government to then export to another EU member state, and then ultimately for that member state to export it to a third country, which may indeed have, a number of problems when it came to human rights, or they may be engaged in a war that Europeans are not generally in favor of. So there was a risk or a fear of the risk that by liberalizing internally the single market, that this would allow us less of a control over what would be exported outside. Now, the ultimate compromise came by firstly disassociating the EU's internal licensing scheme from its export control. And in fact, the directive even strengthened the hand of governments that may have had a fear that any equipment that they would export within the EU would then be re-exported onto a third country. It gave them even more emboldened powers to ensure that that did not happen. So we have a compromise in a different type of way here between internal market liberalization and export policy, which we know is still extremely sensitive for many, many governments in Europe. Again, also with this issue of the transfers directive, again, the question of whether to have a kind of bi-European ethos within the directive was there, because again, it pointed towards increasing the competitiveness of European firms and not non-European or non-EU member states. But again, even within the context of this directive, that argument was compromised out. I mean, it wasn't possible by the end of it to insist upon this kind of bi-European nature. And governments across Europe were essentially trying to reinforce the principles of market openness and free competition in the defense sector. The third case study that I looked at, which is slightly different, is the creation of the European Defence Agency. which has only just now celebrated, I think, 15 years of its existence, was formed in 2004, but in fact had a history before that in terms of its formation. And I found that the EDA was a very interesting case study because, again, it represented a number of national preferences, and it also it signified a very interesting bargaining process. The first thing to keep in mind is that right at the beginning of the idea of a defense agency, and I would say that probably the first EU recognition or mention of this agency was back in 1996. There was a specific communication calling for then an armaments agency, and that was a hangover from the Western European Union, where it was also mentioned. But the idea of this agency had been there for a long time. There were initially some discussions about whether the European Commission should play that role as the armaments agency. History tells us that idea was killed pretty quickly by the member states. And instead, they decided to create an intergovernmental agency. Now, not all member states at the beginning were convinced that we even needed an agency. Some believed it was just an extra layer of bureaucracy that could be used by only a handful of member states to ensure that their interests and their market interests were represented on an EU basis. So that consideration was there at the beginning. There were others, for example, who said, well, we can have an agency. It would be a good idea to have an agency, but it should be more of a network. It should be a small body. It should not be a rather big body that would be able to connect somehow the defense establishments in each of the member states to ensure that they could procure together, that they could develop capabilities together if they wanted. So it wasn't, at the beginning, it was by no means a foregone conclusion that an agency would be created. However, what is really important, and this is a factor which is not picked up by liberal intergovernmentalism, is also the importance of history and circumstance. And it's quite interesting that if you go back to the beginning stages of the EDA, before they were created, this was also a time when Europe was talking about having its own constitution. It was also creating a whole range of new mechanisms. It was also on the verge of the so-called Big Bang enlargement. So in 2004, EU enlargement occurred. And it was a very different political time, I would say, when there were the prospects of greater and deeper integration in many, many different spheres. And so the defense agency should be put in that context, because a number of governments thought that the defense agency also had a powerful symbolic relevance to defense integration at the EU level. And in stating that we needed this agency to make sure that European interests were maintained at all levels in defense policy and defense acquisition and defense research. And I still also remember at the time that the heads of the largest firms in Europe, the firms, it was, well, now it is Airbus, but then it was EADS, also BAE Systems, so a British firm, funnily enough, and also Dassault, a French firm as well, all writing joint commentary pieces and op-eds in newspapers across Europe, calling for the creation of the agency, because for them, they thought that this would be a good opportunity to develop for them a framework, an agency framework in which to pursue, as I said, these European interests, which were very much of the feeling of the time in this different context of political integration at the EU level. So what happened with the EDA after the bargaining process, and this could be observed, that because this was not legislation, because this was the creation of a new institution, you needed new tools in which to control and ensure that this agency would meet the kind of common level of interests or bargained interests and compromise between member states. And how they decided to do this essentially is in two ways. Firstly, on agreeing to what the agency should do. Now, here there was some very, very difficult battles between governments, because on the one hand, some said that the agency should only deal with procurement and development. Others believed that the agency should deal with technology issues as well, and also the development of a specific development of what they called the European Defence Technological and Industrial Base, the EDTIB. So the idea there was that you could use this agency for a full spectrum of issues on defense industrial matters. Not all member states agreed with that. Some argued that actually, no, there should not be any industrial dimension to the agency, that it should just help us as a kind of EU version of OCCAR, of the Intergovernmental Procurement Agency, to help governments procure and develop capabilities together. Well, history will tell you who won that battle, because if you look at the EDA today, they do indeed deal with a whole range, a full spectrum of issues when it comes to the defense sector. So you could argue that those countries that were arguing for a larger interpretation won the day. However, it should also be said that the member states also made sure that EDA was an intergovernmental body. So the idea being that no real policy maneuvers could be made without the blessing of intergovernmental sanction. And today, still, the EDA is a CSDP agency, so it is an intergovernmental body. And that means that member states have quite a veto power over decisions. They also have the right of initiative to launch projects or not within the agency as well. And an added element to this control, I would say, is also the power over the budget of the agency. This is another way in which member states, if they want, can control and ensure that the agency perhaps doesn't overstep its mark in their view, in their eyes. Of course, I'm saying that these were the discussions that were prevalent at the beginning of the agency. These arguments have somewhat changed these days, although the principle of intergovernmentalism still continues to be very prevalent in the EDA. So these, I think, are the three, these are the three case studies that I look at in my book. What do they tell us? If we return to the question which I posed at the beginning, I think it tells us a number of things if we look into these case studies and the theory. On the theory, as I've already said, the issue here is that there are certain weaknesses. The first one being about preferences. As I've said, it is not all about economics. It's also about strategy. It's about military needs. And as I've said, it's very difficult to separate these two types of preferences. The second aspect, which I think the theory is relatively weak on, is on the role of institutions. In my research in the book and looking at each three of these case studies, it was absolutely remarkable the role, at least in the first two cases on legislation, that the European Commission played. And the Commission played, I think itself became part of the bargaining process. So it's not a state, but it acted in many ways as a convening power. It was only because of the Commission that you could find compromise between member states. And the number of drafts that were then made of these pieces of legislation, which then had to be modified, which then the Commission could push back on, the use of wording, the usual legal parameters, the Commission used almost in an ingenious way to make sure that by the end of it, they could find compromise between the member states. And I would say another thing, that after the legislative process was complete and the package was agreed to, the law was agreed to, it also cemented the Commission's role within that process. So it became the key referent, the key political referent, not only in ensuring that what was agreed would be enforced by the Commission and ultimately by the Court of Justice in this case, but also that it was the Commission who was driving forward for a lot of member states the policy on EU-level defense industrial issues. That's the first thing that needs to be kept in mind. But on the other hand, I think if you look at the 3 case studies I've looked at, you also notice a number of other things. And one of the key arguments I make in the paper is that if you look at the EU and you look at the so-called, how can I put it, the promotional material, if you say that governments are involved in EU defense industrial cooperation, it's too easy to consider or to say that they're doing this for the benefit of European integration, or maybe for higher European ideals, and so forth and so forth. Well, that might be in the back of minds of some people, but in policy terms and in terms of power, the power involved in negotiating these terms, I think that that is a bit of a stretch of the imagination. What I noticed was that the EU became a core venue for governments, for many governments, not because of EU integration, but actually because governments were feeling the full weight of international market competition, the full weight of globalization. And in that pressure, they were losing their links with many of their firms, many of their national firms. So the link between governments and defense firms, which had become so prevalent over history, and almost a no-brainer, kind of an automatic situation, was being eroded and questioned by more competition and more globalization. What I say in the book, what I detail in the book, is that the EU offered member states not some higher ideal of a supranational or a fully integrated market necessarily, but it offered member states legal certainty so that they could then go back within their internal national markets and use EU legislation to do a number of things. Firstly, maybe to reorganize their national defense industry, but also to re-emphasize the fact that even though there was a single market, even though there were a number of EU agencies and actors that were developing, that nonetheless, the primary actors in this case were still governments, and firms should probably recognize that as well. And in many cases, they did. So the EU level, apart from, as I said at the beginning, offering governments a level playing field, a kind of the ideals of non-discrimination in procurement, what it also offered was an ability at the EU level to create legal certainty over the link between governments and their firms. And I think this is more of an important conclusion than even thinking about the benefits that have come from the 3 case studies that I show. And in fact, in the 2 directives that I point to, there are still some questions about how effective they are or how effective they have been in creating a single market in defense today. So it's still, even though we had them since 2009, we're still asking that question about how effective they have become. However, and I need to stress this because it's important, and it's a question of timing as well. As I had finished this book, a whole bunch of other new initiatives were being developed and rolled out. And a large part of my current research based on this book, and maybe who knows in the future, there'll be a follow-up publication on this topic as well, is looking at new initiatives like the European Defence Fund, for example, which I've been thinking about very recently since the book has been published, to see how that would fit with the existing theories that we see. And I think it's possible to already draw a number of conclusions from the creation of the Defence Fund. And I'm sure you're all aware of what the fund is, but just in a nutshell, it will be the first time really that the EU has used money from the EU budget for defence capability development and for defence research, to fund defense research. So it's already doing so with its preparatory actions and its industrial development plan. But now in 2021, the idea will be that it will be fully funding projects at the EU level for capabilities and innovation. So it's in itself, it is kind of momentous, and some have called it game-changing reality now in defense industrial policy, because it's not about legislation anymore. It is about financial incentives and ensuring that you have those financial incentives. Now, the EDF is an interesting case study because, firstly, it is an idea that is largely born of the Commission itself. And I would go further in saying that it was actually the former leadership, so with President Juncker, who was really pushing and invested a lot of political energy into getting this fund made a reality.
Daniel, sorry to interrupt you, but I think we should have some time for Q&A, and we have 15 minutes.
Okay.
So for me, it's been fascinating. I could go carrying on listening, but
no, we should take questions. Okay, so we can do that now if you want, and I can even come back to the defense fund if people have questions. I already see in the chat there are two.
Yeah, so what I'm going to do is, for the people listening, you can ask our question on the chat, and then I will open the microphone for you to ask questions. So the first one, we have my great friend, Commander Kurt Engelen. So Kurt, would you please ask your question yourself?
Oh, yes. Thank you, Yanis. Can you hear me?
Yes, absolutely.
Okay. Hello, Daniel. Good to see you virtually, and to see you virtually rather than Brussels, where we usually meet. So a very interesting point about the underpinning theory of liberal intergovernmentalism. And you pointed out in the beginning that liberal intergovernmentalism sees the added value of institutions, especially only at the end of the process. But in the case of the European Defence Industrial Cooperation, the preferences of member states are to a certain extent defined by some prioritization mechanisms, such as the coordinated annual review of defense within the capability development plan, or even by mechanisms of prioritization of NATO for those countries that are both member states and NATO allies. In PESCO, the commitments 18 to 20 under Chapter E even make that cooperation mandatory to improve the European defense technological and industrial base. Now, these mechanisms, they actually belong to the first phase, to the preference setting, but I would argue that they are only possible if they find place in an institutional framework. That means that the institution would have its importance in the first phase. How would this fit in the liberal intergovernmentalist theory? Thanks.
Hi, you can hear me, Kurt?
Absolutely.
Okay. Hi. Good morning. It's always good to see you. I can't see your video, but I see a lovely photograph of you. So that's nice. And you're actually in front of the Belgian flag, which is even nicer. Good morning to you. As ever, excellent question. What I would say is, of course, the book is a snapshot of the 3 case studies that I mentioned, so the legislative defense package and the EDA. Now, if I had to write the book again today, I would probably pick very different case studies, EDF, PESCO being them. I think in the chat you also mentioned CARD, which is another interesting area. What I've said about liberal intergovernmentalism in the book, and I still hold this today, is that it is rather weak in recognizing the role of institutions. And by that I mean in 2 specific ways. Well, one main way actually, that is that liberal intergovernmentalism doesn't give enough credit for institutions as independent actors that can learn, so that can institutionally learn themselves what works, what does not, and also that institutions themselves may actually become the target of bargaining at the EU level, and I can explain that a bit more if I can. But just to say on the point that institutions now like EDA, EUMS, military staff, sorry, and the Commission all play a hugely important role. That's not to say that national preferences go away. They're still clearly there. But one of the innovations, for example, in the EDF, as you know this very well, is also the introduction of QMV for agreeing the work program within the fund. This is a very different bargaining setup than what was there for the two defense directives, which was done primarily on a kind of assumption of unanimity between governments. So that something has changed in the framework in which we negotiate within the defense fund. And as I said, institutions can learn from what has worked in the past and what hasn't. And of course, in PESCO, binding commitments is a recognition, I guess, that, and the process behind that is a recognition that, you know, in the past, it's been very, very difficult to get member states to stick to the objectives that they've signed up to in other parts of defense, you know, the headline goals or wherever it may be. So they try their own experiment, you know, they try to come up with a different structure. As you know as well, PESCO was developed in the treaties, in the Lisbon Treaty, but it wasn't given any real form. It gave objectives, but it wasn't given any real institutional form. That came, you know, later. And of course, institutions played a huge role there. But on this point that I said, you know, what liberal intergovernmentalism often ignores is that it thinks that when governments go into negotiations, that the only interests they have in mind are their economic interests. Now, I've said that that's not true, firstly, that they also have military and strategic interests. However, one of the things I say in my book is that institutions themselves become an object of their national preferences. And by that I mean, does a government feel pleased or comfortable with the idea of handing a certain degree of power, be that convening power, legislative power, to the EU level? In some cases, it may not be in the interests of a member state to empower, especially supranational institutions. It may also lead to governments emphasizing certain formats. So, for example, some governments may say, look, we're very tired, we're displeased with the intergovernmental setup because it is based on pure unanimity and the veto power of member states. Let's try something different. Let's try with the fund, for example, more supranational direction. We may be able to get our interests more seen to or more adhered to within that context than in a purely intergovernmental context. On the other hand, you have member states who would say the opposite thing. Well, you know, supranational structure as it stands, that could be really concerning for us because we probably wouldn't have veto power. We wouldn't have the market power even to make our voices heard within that context. So let's try and push more in the intergovernmental side. What I say in the book, and some of my subsequent writings on this as well, has indeed been that the theory does not really pay too much attention to this. And just as one final comment, for me, from and I know that Kurt is very much also interested in intellectual history as well, but it's really odd that when Andrew Moravcsik started his career, that all he wrote about was armaments cooperation and defense. Then for some reason, he completely dropped it and he started looking at agriculture, whatever, other policy areas, and didn't ever apply LI to defense. So I think and maybe, I don't know, maybe he knew what was coming, I'm not sure. But nonetheless, if you start applying it in defense, you realize that institutions should be given much more power. And it's not to say that if you increase institutional power, you decrease member state power. That's not the point. The point is that member state power can be used in different ways by different institutional formats. That's the point I would make to your very excellent question.
Can you still hear me, Daniel?
Hi, Kurt. Yes, I can.
Okay, Yanis, if you allow me, because that is actually the transition to the follow-up question. That was my second question in the.
Go on.
And that is, when we look back in European history, what we realize, in fact, that there is a number of occurrences where the EU addresses security concerns with economic integration mechanisms. And the very first one was, of course, the European Coal and Steel Community, which in fact was the first supranational institution. And today, we see that most of the mechanisms in the common security and defense policy and in the military field remain in the intergovernmental realm, and that member states are very reluctant to giving up some sovereignty there. Now, with the European Defence Fund that comes from the Commission, which is by essence a supranational institution, my first question is, but it is a rhetorical question, can we see here neo-functionalist spillover mechanism at work that emulates what we already had in DG GROW, and let it emulate and spill over towards defense? And this would be the first time that there is a supranational mechanism at work in, well, if you of course exclude the European Coal and Steel community, but it would be the first time that supranationalism is back. And is there any chance that member states might actually realize the advantage of having this supranational tool, because it's faster, it's more efficient, and it gives more confidence to smaller states to join the club because it becomes more inclusive? Are they ready to give up sovereignty in this field, do you think?
Another excellent question, Kurt. I think you're. By the way, it's extremely good to refer back to the steel and coal and steel community, and it's also another thing which the theories do not pick up on very well. In fact, none of the theories do. In another article, I refer to it as kind of historical serendipity. You know, sometimes there are moments in history which present themselves at the European level, which enable certain collaborative approaches, the creation of new institutions, new legislation, in this case, the European Defence Fund. That, I think, cannot be captured by the theories too well, actually. So these kind of historical accidents or opportunities. On your point about supranational and intergovernmental, certainly. I mean, I took it very much as a rhetorical question, and I don't actually disagree with what you said, in the sense that, yes, we have now at the EU level a kind of governmental, because I think intergovernmental still is very dominant in the strain of organization. But with the fund, it does offer an opportunity for a more supranational direction. And for those member states who want to seize on that opportunity, then it is open for them to do so. Of course, this in itself, we don't have the time, but this in itself is an extraordinarily interesting, opens an extraordinarily interesting discussion on what national sovereignty means today as well. Because, you know, I had these simplistic terms of, well, you know, national sovereignty means that you would be somehow reluctant to negotiate at the EU level, or if you did, it would only be intergovernmental, not supranational. Well, that is not the case. You know, some member states see supranationalism as an ability to actually advance their national interests and national sovereignty. So it is a fascinating case study, which I hope to be able to come to in the future in writing. But the element is that the Commission plays a much bigger role there. It has much more, not just convening power, as you know, it also has much more say in some very sensitive areas, such as capability development. So what should be our capability priorities within the fund? That's the first question. I don't need to tell you, because you know, you're military and you know this, but if you're thinking about capabilities, surely in your mind, you should also be thinking about how you want to use them, you know, in what military sense, what strategic contingencies. You can't really have one without the other. So it means, even though it's not very explicit, but it means in an indirect way, the Commission is already playing a very interesting role in answering some of these questions for us. And what I try to do with people when they ask me the question, well, you know, what type of actor is the EU? I say, well, go and look at the projects which have already been initiated with the preparatory work. Just look at some of the military capabilities that the EU thinks it needs for its needs, and by extension, of course, even NATO as well. It's very interesting. I mean, a few years ago, we'd never have had these discussions about investing in drone technology or AI systems or space-based capabilities for defense. I mean, that wasn't possible until even a few years ago. So it is absolutely fascinating, and I would underline what you were implying in your question. Certainly.
Thank you so much, Daniel. Yanis, back to you, and I want to give the opportunity to others as well to interact, because I could go on for a few hours with Daniel and with yourself.
Yes, absolutely. It is extremely interesting. We have another question here, which is from a colleague, Ilse Vilka, and she preferred to write, and thanks for the very informative insights in your case studies, and maybe you have some ideas how to support and provide more opportunities, or more precise incentives, for small and medium enterprises which want to participate in the European defense supply chains.
Yeah, that's an excellent question. Of course, if I had the perfect example, I think I would be a much response to this. I would probably be a much richer man than I am. That's for sure. It is a fundamental question for SMEs, and it is multifaceted. Of course, it means that the first thing, SMEs should try and understand how the system works much better, especially at the EU level. I still think that there is a huge information asymmetry between what the European Union does, so in Brussels, and what member states and SMEs and firms in countries around the Union know about those processes. So firstly, learning about those processes is fundamental. And I'm sure, if you're asking this question, that I'm sure that you've probably been to many conferences as well that are supposed to support the SMEs. But if you look at the Commission, if you look at the European Defence Agency, a lot of their work now today actually is trying to provide information to SMEs on how you access funds, what are the procedures, what are some of the challenges or obstacles you might face as well. This is very important information, which is also, a lot of it is freely available online, but also, contacting bodies like the Defence Agency, Commission, they have platforms for this type of information. And I think that firstly, that's the first thing we have to do. If you're an SME, you have to learn more about how the system works. Secondly, and this is much more challenging, I'm often asked this question about how firms should position themselves towards the defense fund and to funding. I often think, but I'm not a purely industry man, but I often think that what is missing from a lot of strategies for SMEs and firms is that they don't embed what they want to do in an industrial and technological sense in a broader military consideration. That is to say, that you can't treat the defense fund as simply a kind of cash cow, as it's just money. You have to think, what are your strategic relationships in your neighboring region? So who do you cooperate with already? Who would you like to cooperate with in the future? And not to do so just on a commercial basis, even though I know it will be your most important way of doing it. The question is, how do you position yourselves with like-minded states, with like-minded firms, to be able to really make a mark or an impression within the defense fund whenever certain capabilities or programs are bid for, or contracts are bid for, calls are bid for. So it's not just about the commercial side. It has to be done with much more, I would say, consideration for who you want to work with, who you want to integrate these technologies and components that you develop into systems. Who do you want to work for? So there's the defense supply chain from a commercial point of view, but there's also a kind of defense strategic supply chain, which is to say, well, who are your closest partners? How do you see that developing in the future? Who would you like to work with in the future? This, I'm afraid to say, also presumes that there is a much closer relationship or dialogue between SMEs and central governments, because this overarching strategy of who you want to develop capabilities, defense systems, technologies with, is to a large extent conditioned by governments themselves having the strategic vision to say who their close partners are. And we have, I mean, in Europe, we have already some very, very good examples of that as well. I mean, everyone points to the Benelux cooperation as a primary example. And again, I see Kurt's flag in front of me, so I'm very influenced by this. But Benelux cooperation is a good case study there of where you don't just have industrial considerations and supply chains that function, but you have a broader strategic vision of what you want to do for capabilities, how you see yourself working together as military actors, how you pull sovereignty together. And there are questions that are not necessarily answered by SMEs or firms. They have to be ingrained in a much broader national strategy on how you want to do this. And I often said that for the fund, again, it should not just be seen as a money pot. You have to get out of this mindset of thinking just in commercial terms. It has to be how you're going to use the money and what you develop for a long-term strategic relationship within Europe. It doesn't have to be with all 26 member states. It can be with a small grouping, but you have to start from that awareness and that strategic kind of cohesion on a minilateral basis or even regional basis. So I know it's not a direct answer to your question, and maybe it sounds more theoretical in a way, but nonetheless, I think that is a key aspect that is often forgotten when firms are thinking about EU-level defense cooperation. And the fund, and I'll end on this, the fund is set up in its very DNA to promote that type of cooperation between member states. Even in PESCO, with PESCO projects, you do it on a grouping kind of philosophy of bringing states together in close-knit projects or even geographical groupings. So thanks for the question.
Okay, Kurt raised the hand, so because of timing, I will take Kurt's question as the last one to close was being a brilliant lecture. So Kurt, please ask your question.
Well, actually, Yanis and Daniel, it is more a reaction to the question your colleague asked, and to build a little bit on what Daniel just said. Big countries like France, Germany, Italy, or Spain, who have an integrated tradition of defense industry, they feel it almost like a national duty to take care of the interests of their industry in the defense field. And that means that in every step of the process, they have their own industry in mind. Some other countries have that much less. And in some countries, it is even a kind of taboo. Military people should not talk to the industry, because that would open the way to preferences or even cases of corruption or abuse. And so, in my view, if these countries that rely mainly on small and medium enterprises for the industry, if they want to see an advantage for their industry, it is the states themselves that should set up schemes in such a way that military and industry can talk to each other, and that projects that are started at state level, for instance, within PESCO, and that later go over into industrial consortia forming, that this transition would be smooth and would be supported by the state. So states should help their small and medium enterprises to find their way into the industrial groups that will realize the projects that are originally defined by states. So it is important for these states to enter the projects first, and then to make sure that there is a relay and to put their SMEs in the best possible position to be part of the project when it is going to be able to apply for EDF funding. Daniel, I hope you agree with that answer. But I would be happy to hear your reaction to that.
Very simply, yes, absolutely. The only exception is that I would just say that we should not forget the role of research institutions and academic institutions as well. So
Of course.
the ecosystem should think, it should be more like what the Dutch normally call, you know, the kind of ecosystem or triangle between government, industry, and research institutions. And actually, in the fund that is there, I mean, the fact that some of the money will be dedicated to so-called emerging defense technologies, and also given that the fact that the European Commission next year, well, now and next year, will be working on synergies between civil space and defense. And in this, you know, discussions about, you know, Horizon Europe program, EDF, the space program, synergies between them. I think there's also points to the fact that what we're looking at is innovation in a broad sense. So yes, firms who we know are chief innovators, but also let us not lose what goes on in the academia and in research institutes as well. That's all I would add to what Curtis said, but what he said is correct, yes.
Yeah, but then thank you for mentioning the research sector, and but I would add that especially talking about small and medium enterprises, not the big ones, but small and medium enterprises. I have the feeling that many times they don't really understand the military needs. They don't really understand the military sector, and for developing new technologies, I have the feeling, and this is completely subjective, that because they are unable to understand the threat, but they don't really know what kind of research, what kind of new technologies in the military field are being developed. So I think these small and medium enterprises and many research centers in smaller countries, as in Latvia, for example, would hugely benefit in taking part in the opportunities NATO give. For example, NATO has the CSO organization, and you have the SAS panels, you have many panels, and the government, the national governments could support the SMEs to take part in this, so they understand better the military sector. They learn what the big guys are researching, and so basically it would be some sort of what the Latin American structuralists from the 1950s called associated development. And well, I don't know, but
it is a fundamental point. The only thing I would say is that it is not only experienced in Latvia. It is a pervasive issue in many countries across Europe. And yeah, culturalizing or socializing, this is important. So I would underline that point, actually, that you need ways and mechanisms of ensuring that you can learn from each other. And I would say that it's not just in NATO, but the EDF now, the Defense Fund, really offers that opportunity for SMEs to work together and so forth. But again, don't always think that it's what happens at the EU level that will change things. It's like the Buddhists say, change comes from within. So you have to do something on a national basis as well as working in Europe more broadly. Okay, on that Buddhist note, I will thank Daniel very much for taking the time to be with us this morning, and I will wish everybody all the best, and Daniel too, of course, all the best. And that's it. Thank you. And thank you, Yanis. Thanks for everyone listening, and I hope, again, as I said, in the future we can meet in person. Absolutely. Okay. Goodbye, everybody. Have a good day. Bye-bye.